Hi everybody and welcome to the Brace Law channel. I hope you guys had a great Mother's Day weekend. The weather has been a little bit trippy. It has been quite cold, but today seems to be beautiful anyway. So for today we are going to wrap up some procedures in first appearances as well as the continuation of being charged with a criminal offense. I am going to touch upon the bail variation as well as pretrial discussions, which involve the Crown pretrial and a judicial pretrial. As I mentioned on my previous video, it is quite important to do a bail variation. The reason as to being is so that you can lessen some of the restrictions upon your release. When it comes to varying a bail condition, it is quite important for the Crown that's assigned to your case to agree to the variation. Now, the variation procedure differs from jurisdiction to jurisdiction. I'm always talking about Ontario. However, it's quite similar in almost every Ontario jurisdiction. In some, though, for example, in Newmarket, you would need an affidavit signed by your surety. So the way that it works is the Crown and defense agree on the variation. You come in, you sign your variation. If there is a surety, the surety will sign, the Crown will sign, and then you take it in front of a judge or a justice of the peace to approve it and sign. And there you go. You have a bail variation. Two things that you need to keep in mind when it comes to the bail variation is that you always have to keep it on you in your person or on your cell phone together with your previous release or the previous bail, as well as you have to make sure that the officer in charge has a copy. Usually the Crown's office will send a copy, but it's always good that your defense counsel sends a copy as well, just in case something happens, you get pulled over and it has not been updated in your file. Prior to going to trial, we have pretrial discussions with the assigned Crown to your case. It is important to keep the Crown updated with any accomplishments or as well as any of your achievements and to create a persona for the Crown. There's more to you than just the charge that's been imposed or the charges that have been imposed on you. Pretrial discussions can happen over the phone, they can happen in person as well as through email. We try to always mitigate some factors as well as try to lessen the aggravating factors of your case. It's always good to have continuous pretrial discussions with the Crown to try and come to a favorable position for your matter without the need to go to trial. Sometimes, though, the Crown and the defense do not come to an agreement, so we go to what we call a judicial pretrial. A judicial pretrial is between the defense counsel, the Crown, as well as the judge, and we would like to have a judge's opinion onto the matter. Sometimes the judge will propose something to either the defense or to the Crown or to both to try and come to a favorable position or to a joint position between defense and Crown for the client that's involved. In any event, if a judicial pretrial is not successful and no position is reached, then we set the matter for a preliminary hearing or for trial. So these are some preliminary information that you need to know when you are charged with a criminal offense. It is quite a process. Sometimes clients do get impatient. They want to go straight to trial. Sometimes they want the case to finish early, so they make a plea bargain, but you have to keep in mind that there are continuous discussions between your defense counsel and the Crown, as well as there could be more than just one judicial pretrial depending on the facts of the case. In any event, it takes a while to go to trial, so we often tell clients to be patient because you never know, you can get a favorable position at the end of it all. Anyway, I hope you guys found this video informative. Should you have any questions, please contact us at bracelaw.ca or call and text us, and we will be more than happy to assist you. Have a good one.